listening to Estate at the Union, estate planning made simple. Here's your host, Brad Wiewel, from Texas Trust Law in Austin, Texas.
Hi, I'm Zach Wiewel. I'm an attorney and principal at Texas Trust Law. Welcome to Estate of the Union podcast. I'm joined today by Miss Melissa Donovan. She's another one of our attorneys here. She's been with us for almost 10 whole years, almost a decade, over a decade, sorry. And she's a very important attorney at our firm, and she's actually what we call a CELA, a Certified Elder Law Attorney. She's one of only about 30 in the state of Texas. And Melissa, would you mind explaining a little bit about what that designation means?
Yeah, so Certified Elder Law Attorney, basically my area of expertise and my kind of niche here at the firm outside of general estate planning is working with special needs. So the broad spectrum of what people think of when they hear elder law, you know, long-term care, Medicaid, nursing home care, dementia, things like that. But also on the other side of the spectrum, people who have kids with special needs, dealing with some, you know, guardianship issues and things of that nature.
Yeah. Well, so we're talking about special needs today, and I guess my first question for you is, what is the issue of special needs planning? What is it trying to solve?
Yeah, so what happens is that when we refer to special needs, what we're really talking about are family members, generally speaking, or, you know, I like to say loved ones, because you don't know who the person might be that you're helping. But when people have a disability that precludes them from being able to work and live a kind of typical life and provide for themselves, then they can qualify for government benefits.
Sure.
And there's different types of government benefits, but specifically what we're kind of focused in on this part of planning is means-tested benefits.
Sure. What is means-tested?
So means-tested means that you have to meet certain limitations in terms of your assets and your income in order to qualify for those. So it's not just about having a disability and therefore not being able to provide for yourself working, but you also have to have limited means, hence means-tested. So you have to have, for most situations, you know, you have to have less than $2,000 in assets as an individual. You have to, if you have any ability to earn money, you have to have minimal earnings potential. So hence the means tested. Those are going to be programs specifically like SSI. So I always kind of, you hate to laugh about it because it's a serious subject, but it's also the government does not a great job of making things less confusing. So everything kind of sounds the same. You've got SSI, SSDI, SSA, you've got Medicare and Medicaid. So when we're talking about these things and particularly really honing in, what we're tending to focus on are SSI, Supplemental Security Income, and Medicaid.
So I just want to make or emphasize this. Means tested means you can't really have much means. And one of the standards, because there's a couple different standards, but the main one is you have to have less than $2,000 of assets.
For most people.
That's not that much. As y'all know, that's not that much.
Yeah.
And so that's what special needs planning is for. What's the main issue people are trying to solve, or I guess, where do people screw up the most with special needs planning?
So it depends on the circumstances, but there are a few things. One is that we see historical. So historically, people were kind of told, if I have a child with special needs, I can't do anything for them. Like, I can't leave anything to them. So
they'd be cutting the kids out.
Exactly. They would be essentially disinheriting the child who needs the money the most because they can't provide for themselves. And, you know, there's pitfalls in that because it's not, I always tell our clients when I'm talking to them, it's not necessarily that we don't trust the other child. So if, let's take an example, if we've got two children and we've got Johnny and Sally, and Johnny is the one on benefits, so Johnny's being cut out, we're leaving all the money to Sally.
Yeah.
It's not that I'm going to tell a client, because it's not this. It's not that we don't trust that Sally wants to take care of her brother or would do the right thing. But what you typically see in those scenarios is we're just giving it all to Sally. So now Sally might have $500,000, $1 million of an inheritance that goes into Sally's bank account.
Sure.
And then as much as Sally's going to do the right thing, Sally's in a car accident the next day.
Yeah.
Sally's husband leaves her, and now there's a divorce where that money is at play. So it's kind of one of those things where, I don't know, and I know your dad well, I don't know if he ever used this with you, because this is what my dad was always like with me. It's that kind of fatherly, parental, like, it's not that I don't trust you, it's the rest of the world that I don't trust kind of mentality.
That's fair.
And that's the issue with that. The other thing is if they do absolutely nothing, like we still have the vast majority of people in the country who die without any planning period, regardless of special needs planning. if you have a child that's on SSI, on Medicaid benefits, and you've got nothing in place, well then, as you know, we're going to an intestacy.
Yeah.
And it's all going outright. And now we might have thousands or hundreds of thousands of dollars going to someone who is going to lose their benefits because they did nothing. They just kind of put their head in the sand.
What happens with that is basically it's like wasting an inheritance. Is you leave it to that special needs person in the wrong way, and so now they have too much money. They're kicked off of their means tested assistance because they have too much money.
Exactly.
And then they use the entire inheritance paying for the same care they were getting, and once
to get right back on benefits once it's gone.
Yeah.
Yeah. And there is, there's a line, but a lot of these kids who do end up on these benefits, they have very expensive needs. Like I've had clients with children who have very severe cerebral palsy. These are conditions that some of them, could millions of dollars over the course of this child's lifetime to care for them. So special needs trusts are really, really important, to be able to provide for those things that maybe Medicaid can't cover, or Social Security, SSI, it's $960 a month. That's not going to cover that much.
Yeah.
So you can pay for housing and make sure that your kids are taken care of when you have the possibility of doing that.
Then let's go ahead and talk about special needs trusts, because that's one of the main ways you can do planning for someone with special needs. Let's just start with first party really quickly. What is a first party special needs trust?
So a first party special needs trust is where I'm going to put myself, so pretend that I am the person who has the disability and I'm the person on Medicaid, I'm the person on SSI. So a first party trust means that I am creating that trust for myself.
Got it.
Hence first party. It's my money, I'm creating the trust for my benefit.
Yeah.
And those are used in very specific circumstances. You oftentimes will see those being set up when there's, let's say, a medical malpractice settlement.
Sure.
Or if somebody who has a disability is in an accident and now there's like a car accident settlement coming in, you can place that money under certain circumstances. There are age restrictions and things like that. But you can put that money into a first party special needs trust where essentially by doing that, the government is saying, if you have this money in your name, we are not going to cover you because you have too many assets.
Sure.
But we will allow for you to create this trust for your benefit so that we will continue covering you and you'll have access to that money to take care of the things that we don't cover for the rest of your life. But
there's a
big but
con to this.
Okay? When you then pass away, we as the state get paid back.
Yeah.
Because essentially we're being magnanimous and allowing you to create this trust so we keep paying for your benefits. But we have to be paid back for that if there's anything left when you pass away.
So let's say that this situation happened. You set up a first-party special needs trust for yourself, and the government spent $200,000 on your care.
Yes.
And then you die. What you're saying is that when you die, the government gets paid back first that $200,000 before the rest of your money can go to your loved ones.
Exactly.
Gotcha. So big con of doing a first-party special needs trust. Sometimes they are the only option, and sometimes they're the best option. But you want to be careful when doing first-party special needs trusts.
Right, and there is a lot of confusion because oftentimes, and I know. I don't know if you were a science kid growing up, and I know
I like space.
I know most of us as lawyers, like we went to law school because we weren't math science people.
Yeah.
But if you remember being back in, I don't know, it was like 6th grade or whatnot, when you first started learning about genes and you had the square, with the X and the Y axis.
Yeah.
I always kind of go through that when I'm talking to clients about special needs trust because you have first party, third party, and then you have lifetime and testamentary.
Yeah.
So it's kind of like checking the boxes to see which one you're going to be in.
Yeah. Well, let's go ahead and talk about third-party special needs trust, because in the right situation, in a lot of situations, that is the best planning technique. So what is a third-party special needs trust?
So the biggest difference with a third party, so going back to the example I gave, where I am the actual individual with the disability and I'm receiving SSI, I'm receiving Medicaid. First party means I create it with my money for me.
Yeah.
Pretend you're my brother, okay? We spend enough time together.
Right.
So you want to create a trust for me.
Yes.
You are a third party.
Gotcha.
So
I'm giving money to you.
You create the trust with your money for me as the beneficiary.
Gotcha.
Third party, so then that money can be used for my benefit for the rest of my life as the individual with the disability. But the kicker is it doesn't have to go back to the state.
It can just go straight to
Right.
who I say it goes
Whoever
to.
you say it goes to. Because, and this is the way that works, and if you think about it just kind of logically, when it's a first party trust, it was my money to begin with, and I wouldn't have qualified for those benefits but for the government letting me do that trust.
Sure.
Third party, it was never my money to begin with.
Yeah.
It was your money. Never mine. Therefore, it doesn't have to go back to the government when I pass away. You have full control over where that goes.
Sure.
Yeah.
Okay. Well, I guess another kind of question on this is you say it's providing what the government's not providing. What's a few examples of that, of things it can supplement?
Yeah. So I like to use the kind of term everyday luxuries. So these are the things that just in typical life, truthfully, we probably most of us take for granted.
Sure.
So like I said, if you're getting SSI, it's about $960 a month. So it's not going to be able to cover everything that, people might take for granted, like I said.
Yeah.
So it can cover things like entertainment. It can cover educational expenses. It can cover, going to the movies on Friday night with your friends, although
Yeah.
I don't know how many people go to the movies anymore.
I go to the movies.
Going bowling, whatever you want to do for fun. Vacations.
Yeah.
You can pay for the individual to go on vacation, and in many circumstances, especially with third-party trusts, you can pay for, some of the family to be able to accompany that person on vacation. You can pay for health care that's not covered by Medicaid. So if there are special therapies, treatments, medical equipment that are not being covered by Medicaid, that special needs trust can cover that. And in many situations these days, because in the past, a lot of special needs trusts did not allot for this because people were more concerned about it. But you pay for housing, that's the biggest one.
Yeah.
There is a little bit of a downside if you're not really careful with housing and utilizing ABLE accounts and whatnot in conjunction with it. But the benefit of paying for housing is there's a rule with Social Security where if somebody pays for historically food, shelter, or clothing, and they've kind of eliminated some of those over the years, but the biggest one being shelter. If someone pays for someone's shelter who is receiving Social Security benefits, meaning that the individual is not paying rent or covering those costs through their Social Security, then they're going to lose a third of their Social Security check. So basically about $340, $60 a month, give or
So
take.
you kind of have to do a cost-benefit analysis. If I'm losing $300 a month, is it worth it to get better housing?
Which in most cases
Yeah.
it is.
Yeah.
Because, we're in Austin.
Yes.
So good luck finding a room around here that's going to be less than like $800 a month probably. So if you want to put your child in, the nicest possible place you can, whether that's individual, they can live in their own, or to the other end, like they have to be in a group setting, but you want to pay for, the best care that you can in that group home setting or in that, facility setting, you could pay $2,000, $3,000 a month for the housing for the beneficiary. They're going to lose $360.
Not too bad.
Most people are going to say that's worth it.
Yeah.
I want my kid to be in a better place. And the benefit with Social Security, realistically, for a lot of individuals, the benefit of Social Security, the larger benefit, is the Medicaid benefits that you receive with it. Because the way Social Security works, you can have a lesser amount of Social Security as these other rules kick in, or if, let's say, somebody is part-time working, so that can kind of lower the actual Social Security check. But so long as you keep $1 of Social Security SSI, you keep your Medicaid benefits.
Huge.
So there are many people who that's how they live. They might not have a full Social Security check because they have these other things and they're working a little bit, but they get at least $1, they keep their Medicaid benefits, and that's huge because, like I was saying, if you've got different disabilities, it could be hundreds of thousands of dollars in care. Yeah.
So you mentioned something earlier, and it was going back to the science class, and you have the first party, third party, you have lifetime and testamentary. So what a testamentary trust is it's a trust that's formed when me as the person giving the money when I die.
Right.
So what's the difference, or I guess how would you plan differently between a testamentary and a lifetime third-party special needs trust?
Yeah.
Why would you do one or the other?
So there are kind of different family issues that come into play. The biggest thing that I always kind of talk through is who do we expect is going to want to provide for the child? So if we go back to the Sally and Johnny example, and if mom and dad are sitting across the table and we have a conversation, one of the first things I'm going to ask is, who in your family is likely to want to give money to Johnny?
Yeah.
And are they going to give it to Johnny while you're still alive? Or like, let's say, grandma and grandpa, are they gonna like funnel it through you?
Sure.
So as you kind of know, in a typical estate planning scenario with families, most people don't directly give to grandkids. Like it kind of goes from, grandma,
Generation to
grandpa
generation.
to mom and dad, so on and so forth. But there are certainly scenarios where different family members are going to provide. So like myself, for example, like, I don't have children. So if I had a nephew or a niece with special needs, like I
wanna
might
give it to
want to
them.
give it directly to them.
Yeah.
So those are the questions that are really important in determining, what's the best case scenario in this family situation. And if somebody is saying, well, it's just me. Like, I don't expect that grandma, grandpa, or I don't have siblings that are going to leave money to my child. It may be very well possible that all that we need to do is a testamentary trust.
Sure.
So, that client might have their own will or their own living trust, and that special needs trust is only created within that document, that person's will or that person's living trust of their own. But if they say, well, I'm pretty sure, my aunt is going to want to leave money and my mom and my sister, then the idea becomes, well, maybe we want to have one bucket that everybody can give to. And that's where we're going to do more of a living special needs trust, a current in place, create it now. And, that's the bucket.
Yeah.
We can all pour into it.
Yeah.
So it doesn't necessarily work in every scenario. There might be situations where, a child might have a special needs trust from mom and dad and one from grandma, grandpa. There are certainly reasons and tax situations where that is, a valid and viable way to do things. But oftentimes if there's other family members that are going to give, we're going to probably want to do a lifetime one.
Okay.
Get it set up, allow it to structure.
So another question, because I've seen this in a lot of plans, questions of fairness. Which is always difficult because a lot of times I'm a child, you're a child, all of y'all are children to someone. But there's always a question of fairness when you're doing an estate plan. Do we give Johnny, who has special needs, do we give him more? Do we give him less?
Yeah.
How does that come into play?
Again, I know people love the lawyerly "it depends" answer, but it does, because it depends on the family, it depends on the level of disability. But one thing I will always tell clients is, across the board, I am not a big believer in fair always means equal.
Sure.
It doesn't. Like, realistically, in most scenarios, there's situations where somebody has a bigger need for help. But we've done it all across the board. I have clients who, things are able to split equally because there's plenty of money to go around, as they say. I have other clients who, we've got Johnny, and Johnny is never going to be able to provide for himself, and we've got Sally, who has a great job, and she's doing really well, and maybe we want to put more money into Johnny's trust.
Sure.
And, knowing that, let's say a scenario where Johnny doesn't have kids and he's not going to be able to have kids in the future, whatever is in Johnny's trust is probably going to come back to Sally anyway. But during Johnny's lifetime, having more money there for Johnny can be really helpful. And then we're also kind of taking a little bit of pressure off of Sally to feel like she has to then dig into her own stuff to add to what Johnny needs. Again, every family is different, but generally speaking, more often than not, when there are multiple kids, one being special needs, or maybe two being special needs, we will oftentimes see that child will have more in the kind of division of things. Very rarely, but it has happened where I've had clients give a little bit less to that individual. But it's a very specific to the family situation, because just like with many things, saying someone has special needs is not like everybody is the same thing. There's all sorts of different disabilities across the spectrum, different levels of ability. So that all comes into consideration in figuring out.
Another question I had, or just something to talk through, because I think this might be the toughest planning thing to kind of plan around. And it's who's going to manage the money, who's going to be the trustee, because trusts, there's things out there called trust companies, and they manage money, but you also have humans who can manage the money, like your sibling, an aunt and uncle, someone. What, from your perspective, I know it depends, it definitely depends, but what are the kind of pros and cons? Just talk me through that conversation.
Oftentimes, we will kind of lean more towards, with special needs trusts, if we can. And I say that because there are circumstances where it's not realistic. But if we can, we oftentimes prefer to have a professional manage a special needs trust because of the level of intricacy involved in having to manage it. As you know, we do a lot of trusts for our clients that are, more just checkbook trusts, as we like to call them. They're asset protection. We're giving the money to all the kids, and they can be their own trustee. It's just to provide, the protection from the divorces and lawsuits. Those are a little bit easier to manage. There's not as many rules that come into play. When dealing with a special needs trust, there's a lot of rules. And then there's a lot of changes. So the reason that we tend to kind of err on the side of caution, as I would say, in saying that a professional would be a better suit for managing that, is because you have to know that this person is not going to make a distribution that at any point in time is going to cost the beneficiary their Medicaid or their Social Security benefits. Those rules can change all the time. So it's hard for somebody who doesn't kind of day-to-day work in that world to keep up with those things. Now, that being said, there are certainly scenarios where, maybe there's not a likelihood, like a high likelihood of having a professional being able to manage it. Because as you know, with trust companies, they all have minimums. Maybe we don't have enough money in the trust to hire that trust company.
Well, also they charge a lot of fees.
And they charge a lot of fees. So in a situation like that, we kind of then have two options depending upon what assets. And these, again, are personal conversations, because sometimes if it's relatively simple structure of assets, we might want to utilize what are called pooled trusts. So here in Texas, we have ARC, and that's our master pooled trust, and those are great in scenarios where we might have a smaller trust. And
let's take a moment and explain those a little bit more.
So the way a master pooled trust works is it's run by generally a nonprofit. Every state has them. In some states there are multiple. But the way that it works is, think about it as you have thousands of people with what we would refer to as small trusts. Maybe John has $100,000 in his trust and Sally has $50,000 in her trust. And we're not going to be able to have a professional manage that as a trust company because their fee would eat it in 2 years. Okay. So with a master pool trust, what they're essentially doing is, everybody, think of it as like their own little sub account. But all of those sub accounts are kind of pooled together for management purposes, which allows the fees on that to be very low comparatively.
It's just scaling it up. You spread the cost over a lot more people, and so it's easier for...
So with the pooled trust, the biggest difference is that there's no minimum annual fee, because that's what tends to be the issue with the trust companies, is that yes, they might charge 1%, but then they have a minimum annual fee of $8,000, $10,000, $12,000. So if you have a $100,000 trust, you're not being charged $1,000.
Well, because the beneficiary is also using some of this money, and it could be gone in 3, 4, 5 years.
Exactly. So that's where those pooled trusts become really helpful, because maybe you have that $100,000 trust that, as a fiduciary and ethically, a trust company is not going to accept it because they know that. They know that their fee is going to eat it. So that we can use that pooled trust, put it all into that lump together, and then that $100,000 trust, they are only being charged $1,000. But it's not necessarily a personalized trust the way that, like, if I were sitting down and drafting out trusts and going through specific provisions with a client, those trusts are going to be essentially like boilerplate. Like we all know, you log in and you sign up for Facebook or whatnot. You have the boilerplate contract. Very similar. I mean, not the same, but similar. You've got kind of 4 options. You pick what makes the most sense, but those can be really, really helpful. If we have a more simple, like, we know it's going to be cash that goes to the beneficiary. Other than that, then if, let's say, mom and dad want to keep a house in there, or we've got retirement accounts that are going to go, we may have to have a family member or a friend manage that trust. In which case, the advice I always offer is, we want to choose somebody who kind of knows what they don't know. You want
They're smart enough to know that they don't know this.
You want to have the person that knows, okay, I'm going to go talk to a professional before I do something that I'm not sure of. You don't want to have the person that just kind of flies by the seat of their pants. Because then you're putting the beneficiary at risk.
Another question for you, because this comes up because, the United States of America, it's a big place. And the thing is, a lot of these rules, they're state specific. So let's say we have a special needs beneficiary. We're working with the Texas clients who's giving money to a special needs beneficiary located in Florida, Mississippi, New York, and other states. What do we need to consider when that comes up?
So generally speaking, there's, again, going back to that question of testamentary or a lifetime. If we're doing planning as a testamentary special needs trust, typically what we're going to suggest is, we will do the planning based on the way that the laws work in Texas. However, we generally want to have an attorney in the state where the beneficiary lives, at least do a review on things to make sure there's nothing that needs to be tweaked in there. If it is a standalone trust, we generally speaking, the best option for the beneficiary is going to be to have an attorney who's licensed in the state the beneficiary lives in. Draw up that trust, because the rules for that trust they don't need to be based on where I live as the person creating it. They need to be based on where does the actual person who's receiving benefits live. And generally speaking, the rules are not drastically different from state to state.
But there's nuances.
But there are nuances. There are little things in the way different states treat different types of assets or income. So you just want to be really, really careful. And there are some states that are a little bit more restrictive on distribution standards, others that are less restrictive. So that's why it's really important that you're taking into consideration, where does the beneficiary live? And if the beneficiary moves, we might need to adjust sales.
We'll end on this question because it came up in a meeting we did a couple months ago, but it's law changes or regulation changes over time. What issues does that cause? How do we solve those issues?
And it's hard because it depends on the circumstances. And I'm going to kind of hone in and focus more so on third-party trusts. And depending on scenarios, when it comes to legal changes, oftentimes we can do what we would refer to as a revocable third-party special needs trust. If we're not planning on funding the trust immediately,
not putting money into it.
Right. If we go back to the example of the trust is really like the bucket that's sitting there waiting for everyone to give to, then we can use a revocable structure so that if 5 years down the road there's a change, it is very easy for mom and dad to go back and amend that trust. It's still revocable. They can do that. Now, there are certainly scenarios where a revocable trust is not going to make sense. So say, for example, we know we're going to immediately want to fund this trust with, hundreds of $1,000s or whatnot. We might make that irrevocable to begin with. With a third-party trust, we can utilize what are called trust protectors. So I know you are very familiar with that. We do that with all of our planning, generally speaking, with our trust clients anyway. But trust protectors can be really, really helpful. So what a trust protector is it's an individual or a professional who is designated within the trust document so that if the trust is irrevocable, and then there is a change in law later on down the road, so the trust maker, the grantor, the person who creates the trust no longer has the right to change it. And the beneficiary can't change it, and the trustee can't change it. But if you have a trust protector and proper provisions in there, and let's say there's a rule change about, well, now we can't pay for housing, or now we can pay for this, and it's not an issue any longer, that trust protector can actually go in and amend the document. So that now we are flowing with the new laws. In third-party trusts, we always want to, in my opinion, I think it's really important to have those in there. You can't do that quite as much with first-party trusts because those are far, far more restrictive.
They're just a different world, too.
A little bit of a different animal, more restrictive, like I said. But with third-party trusts, you have a lot more flexibility. So I always want to have a trust protector there just to make sure that you're following those.
One thing to know as we kind of finish this podcast is all the plans that we draft, whether it's a will or a trust, let's say you're planning and you're giving your money to your children or your loved ones, and no one has special needs right now. But then after you sign the will or after you sign the trust, something changes. They get in a car accident. They have a grandchild who develops special needs. So what do all of our wills and all of our trusts do in that situation?
So everything that we do has what we refer to as a contingent special needs trust. So contingent meaning it's there just in case.
Just in case,
Because like you said, you don't know. None of us have the crystal ball to know that our family for generations and generations and generations is going to be perfect and fine. So that's what the contingency is there for.
Okay. Well, thank you all so much for watching this podcast. We really appreciate it. Melissa, thank you so much for coming on. This is an awesome conversation.
My pleasure.
Thank you all for watching.